Hi there, thanks for tuning in. My name is Pretorius, attorney and director at RP Attorneys, Pretoria. I'm here to provide a crash course on the Protection of Personal Information Act 4 of 2013. Promulgated in 2013, the Act's purpose, amongst other things, as per its preamble, is as follows: to promote the protection of personal information processed by public and private bodies, to introduce conditions so as to establish minimum requirements for the processing of personal information, to regulate the flow of personal information across the borders of the Republic, and to provide for matters connected therewith. The Act further acknowledges Section 14 of the Constitution of South Africa, being the right to privacy, adding that the right to privacy includes a right to protect against the unlawful collection, retention, dissemination, and use of personal information. The goal is to regulate, in harmony with international standards, the processing of personal information by public and private bodies in a manner that gives effect to the right to privacy, subject to the justifiable limitations that are aimed at protecting other rights and important interests as well. POPI has in the Act numerous definitions. I will not be, for this purpose of this video, be focusing on each and every one of them, but for reference it is contained in Section 1 of the Act. But for purposes of this slide, I'd like to please refer you to the definition of data subject, and that is the person to whom the personal information relates. For example, body X holds information of person A and person B. Because X holds information of A and B are regarded as data subjects. A responsible party would be a public or private body or person who determines the purpose and means for processing personal information. The example of above, body X would be the responsible party in this scenario. The information regulator is the state institution established in terms of POPI and regulates not only the legislation but also the execution and application of POPI in practice. Processing is basically the use, collection or retention of personal information held by that responsible party in relation to any data subject. Furthermore, personal information would be any information that relates to data subjects, albeit a natural person or a juristic person that lives or exists, and it means information relating to an identifiable living natural person, where applicable, an identifiable existing juristic person. The Act makes reference to numerous examples, from names, identity numbers, cell phone numbers, the works. It is not a closed list, and the test should rather be whether the information can relate to a certain person or not. As such, I would not say you should only rely on the definitions that are set out in the Act. POPI applies when personal information is processed by a responsible party, where the responsible party is domiciled within the Republic or uses automated means throughout the Republic. Section 3 further indicates that this Act must be applied in such a manner that the responsible party is not prevented from exercising or performing its powers, duties and functions. There are numerous compliance provisions contained in the Act, and in theory it makes sense, but in practice it would be rather tedious to follow. As a result, the Act does make it clear that the Act must only be applied in a reasonable manner that is not preventing from the responsible party from exercising or performing its powers, duties and functions. As such, this differs on a case-by-case basis, and just please keep that in mind as well. In certain instances, POPI does not apply, and it's set out in Section 6 and 7 of the Act itself. This would include where the processing is done solely in the course of purely personal or household activities, processing of personal information that has been de-identified to the extent that it cannot be re-identified again, the processing of personal information by or on behalf of a public body which involves national security, including activities that are aimed at assisting in the identification of financing of terrorism and such related activities, defense or public safety, or the purpose of which is the prevention, detection or assistance in the identification of the pursuits of unlawful activities and the combating of money laundering activities, investigation or proof of offences and the prosecution of such offenders, or the execution of sentences or security measures to the extent that adequate safeguards have been established in legislation for the protection of such personal information. The processing of personal information by the Cabinet and its committees or the Executive Council of a province, or the processing of information is solely for journalistic, literary or artistic purposes, insofar as this exclusion is necessary with regard to the right to freedom of expression. The data subject, that means you and me, and any other person whose information is collected by a responsible party, has certain rights as contained in these various sections of the POPI Act. So firstly, the person has the right to be notified that his personal information is being collected in terms of section 18 of the Act. Also to be notified that the personal information of him is being collected unlawfully. To establish whether the responsible party holds information of that data subject and to request access to it or its personal information in terms of section 23. To request correction, destruction or deletion of his or her personal information in terms of section 24. To object to the processing of his or her personal information in terms of section 11. To object relating to the processing of his or her personal information for purposes of direct marketing. Not to have his, her or its personal information processed for purposes of direct marketing by means of unsolicited electronic communications except as referred to in section 69(1), or to submit a complaint to the regulator regarding the alleged interference with the protection of the personal information of such data subject, or to submit a complaint to the regulator in respect of a determination of an adjudicator as provided for in terms of section 74 of the Act. Also, this person has the right to institute civil proceedings regarding the alleged interference with the protection of his, her or its personal information as provided for in section 9 of the Act. So, you'll see I'm referring to these 8 blocks as the Hateful Eight in reference to a movie of Quentin Tarantino that I find very interesting. This should not be regarded as identifying these various conditions as violent as the characters in the movie itself. But regardless, I thought this was rather fitting. The foundation of lawful processing of personal information in South Africa is founded on these 8 conditions summarized in section 4 of the Act: accountability, processing limitation, purpose specification, further processing limitation, data subject participation, security safeguards, openness and information quality. I'll be discussing all this in the next few slides. Yes. Firstly, the condition of accountability entails that the responsible party must ensure that the conditions of lawful processing and all the measures that give effect to such conditions are complied with at the time of the determination of the purpose and means of the processing and during the processing itself. This includes the duties of an information officer contained in sections 55 and 56 of the Act as well. From face value, this condition seems fairly straightforward, yet upon further inspection it becomes clear that this also requires the party to exercise measures to give effect to all these conditions. Compliance with the Act is therefore not a box-ticking exercise, but also that of substantive compliance. To start on this journey, we need to look at the information officer, who is an officer appointed, who must be in a position to conduct the following: encourage POPI compliance with these conditions when processing information, deal with requests made to the responsible party in terms of POPI, otherwise ensure overall compliance with the Act, liaise with the regulator with regard to investigations, register with the regulator as an information officer. And furthermore, officers must take up their duties in terms of the Act only after the responsible party has registered with them with the regulator. Unfortunately, at this time of recording, the information regulator's website and email service is down for registration of information officers, and as such those deadlines have been extended until such time that the infrastructure has been sorted out. So yeah. The second condition is that of processing limitations. The Act limits the processing of personal information to one instance: that this processing is lawfully and reasonably done in a manner that does not infringe the privacy of a subject. Over and above lawfulness, information is only to be processed for the sole purpose for which it is obtained in a manner that is relevant and not excessive. In order to comply with this, information will only be processed in one of the following instances as set out in section 11. The data subject has consented to the processing of information. The processing is necessary to carry out actions for the conclusion or performance of a contract to which the data subject is a party. Processing complies with an obligation imposed by law on the responsible party. Processing protects legitimate interests of the data subject. The processing is necessary for the proper performance of a public law duty by a public body, or processing is necessary for pursuing the legitimate interests of the subject, the responsible party, or of a third party to whom the information is supplied. Furthermore, the Act expressly states that the burden of proof for a subject's consent lies with the responsible party. Furthermore, the Act also grants the subject the following rights: the right to withdraw his or her consent at any time, the right to object to the processing on reasonable grounds pertaining to the subject's situation, unless the law provides for such processing. The Act in section 12 places an obligation to collect information directly from the data subject unless one of the following exemptions apply. The information is part of public record, or the subject made it part of public record, which also includes social media. So let's say, for example, on your local Facebook group, you're seeing one person is advertising a service and asking people to leave their details if they are interested, and the next thing you know, you're seeing a comment section flooded full of cell phone numbers. For purposes of collection directly from a data subject, this provision will not apply to that information that's shared in that comment section, also including WhatsApp, LinkedIn, Twitter, Instagram, anything of the sort. The other exemption from direct collection includes the subject has consented to collection from information from another source. This would be the instance where verification needs to be done and the person agrees that the information can be collected from another party. Let's say, for example, an employer considering the employment of a job applicant and like to contact the previous employer for further information on his or her job performance. The applicant can then confirm his or her willingness or consent to you, the employer, potential employer, contacting the previous employer. Also, direct collection is not necessary if the collection from another source does not prejudice the subject's legitimate interests. For the conduct of proceedings in any court or tribunal, this includes the CCMA and any other tribunal other than the courts in South Africa. If the collection from another source than the subject is in the interest of national security, collection from another source is necessary to avoid prejudice to the maintenance of the law by any public body or to comply with an obligation imposed by law. Furthermore, to maintain the legitimate interests of the responsible party or of a third party to whom the information is supplied. Also, indirect collection would also be allowed if compliance with the direct collection requirement prejudice the lawful purpose for such collection. This would more fully be related to investigations either internally or by the South African Police Services, anything of the sort. And whether it would be reasonably impractical to expect of a responsible party to collect the information directly from the data subject. Furthermore, third condition being purpose specification set out in sections 13 and 14. Your collection and retention of personal information must be done for a purpose as set out above, that is specific, explicitly defined and lawful, insofar as it relates to your function that you as a responsible party are carrying out. You must take the necessary steps in terms of section 18 to ensure the subject is clearly aware of the purpose of collection. Records of information cannot be retained for a period longer than is necessary for achieving your purpose unless any of the following exceptions apply. You are authorized by law to retain these records for a certain period of time, looking at FICA requirements, tax requirements, anything of the sort. Retention might be required of you for lawful purposes relating to your functions or activities. Retention is required by the contract between you and the subject. The subject has consented to further retention. Retention is for historical, statistical, or research purposes, with the requirement of appropriate safeguards in place to ensure it is used for no other purpose than that. If you have used personal information of a subject to make a decision about the subject, you must retain the record for such period as may be required by law or code of conduct. You must retain the record for a period which allows the subject a reasonable opportunity to request access to the record. You must destroy or delete the record once it serves no further purpose or retention is no longer authorized. The processing of personal information must be restricted if its accuracy is contested by the data subject himself or herself. The information is no longer required for achieving the purpose for which it was collected or is retained for purposes of proof. The processing is unlawful, while the subject opposes destruction or deletion and requests restriction instead. The subject requests transmission into another automated processing system. Further processing. Further processing is defined by the act of processing of information that takes place when a reasonable party processes information in its possession for purpose other than which it was collected. This is regulated by section 15. The key principle here is whether the further processing is compatible for the purpose for which it was collected initially. The responsible party must take account of the following: the relationship between the purpose of further processing and the purpose for which it was originally collected, the nature of information concerned, consequences of further processing for the subject, the manner in which the information has been collected, contractual rights and obligations between the parties. And Section 15 indicates instances where further processing is lawful from the get-go. This would be the information is public record or is made public by the subject. Further processing is necessary. It is required to avoid prejudice to the maintenance of law by any public body, to comply with an obligation imposed by law, for the conduct of proceedings in any court or tribunal, again including forums such as the CCMA or bargaining councils, in the interest of national security, or where further processing is necessary to prevent or mitigate a serious and imminent threat to public health or safety, the life or health of the subject or another person. Furthermore, further processing will also be allowed if the information is used for historical, statistical, or research purposes. So let's say, for example, you run a McDonald's franchise. Again, I'm speaking with absolutely no knowledge of McDonald's franchise rules, so take it with a grain of salt what I'm going to explain here. Again, also just for purposes of this example. You own a McDonald's franchise and you initially interview various employees, candidates for the roles of store staff. In this instance, then you would then use their personal information to determine whether they are fit for the specific positions, and based on that information you will then be making a decision from the outset. Above and all that, let's say 3 years down the line you decide, you get asked by a shady insurance broker to pass along certain bits of information, of your employees, so you can sell them insurance products or possibly investment products. Again, this person is not getting information in the correct manner, so applying the test of compatibility, this would fail for the sole purpose of getting information for the purpose of employment and sending information for the purpose of shady broker deals aren't necessarily compatible with each other. Let's say, for example, one of your employees, Joe, initially gave his information 3 years ago. He's been working in the store ever since, and he's applying internally for promotion to store manager. Now, you're going to process his information again, the same information that you used years ago to employ him into the company, and now you're considering whether or not he's fit for the role of store manager. So now obviously it would be compatible because his information is shared for the purposes of employment. or further employment in the company. Fifth condition is that of quality of information as set out in section 16 of the Act. The responsible party has a duty to ensure and take the necessary steps to ensure the information is complete, accurate or not misleading, and updated when necessary. This would be, where persons might have lied in their CVs and you have found out about that. It is your job to make sure that is the correct information then ultimately, and not, taking everything for granted, accepting everything on face value of what the person is telling you. So you are still allowed to do your own verification as well. Let's say, for example, a person's university qualifications are recorded in a CV, but when considering or contacting the university, finding out there's no such person in the records, you can arrive at a conclusion that this person's information is actually, false. It is then your duty to ensure that is in fact the case. Alright, principle of openness or condition of openness as set out in section 17 and 18 of the Act. You as responsible party must maintain documentation relating to your operations and notify the subject in terms of section 18 of the following: information being collected, the source of the information if it is not collected from the subject, your name and address being the name and address of the responsible party, purpose for which the information is collected, whether the supply of information by the subject is voluntary or mandatory, possible consequences of failure to provide the information, any law authorizing or requiring the collection of information, whether the information is intended to be transferred to a third country, and if so, whether that level of protection afforded to the information by that country is of a better standard or similar standard to that of South Africa. Again, South Africa is one of the later countries who only, created these laws relating to data protection at a later stage. So most likely countries where GDPR and those laws apply already provide actually better information security than South Africa. So you'd be safe in that instance. Furthermore, the recipient or category of recipients of the information needs to be known to the data subject, the nature or category of information requested, the subject's right to rectify information collected, object to processing, lodging a complaint with the regulator, along with the regulator's contact details. These steps referred to above are crucial and must be taken before the information is collected, unless the subject is aware of the above mentioned information, or if the information is already collected, as soon as reasonably practical. You only need to follow this process once if the purpose of the collection of information remains the same. This process does not have to be followed in one of the following instances: the data subject has consented to non-compliance, the legitimate interests of the subject are not prejudiced, non-compliance is necessary to avoid prejudice to the maintenance of the law by a public body or to comply with an obligation imposed by law, for the conduct of proceedings in any court or tribunal, if it is in the interest of national security. Compliance with this rule shall actually prejudice the purposes for collection. Compliance is not practical in the circumstances. The information will not be used in a way in which the subject is identified, going back to the security cameras counting feet in a certain area, or the information is used for historical, statistical or research purposes. The Act also has a condition relating to security safeguards. So after collecting the information, you obviously are going to store that information, albeit electronically or in a hard copy. You as a responsible party must ensure the integrity and confidentiality of personal information by taking the appropriate, reasonable technical and organizational measures to prevent loss, damage, unauthorized destruction of personal information, and unlawful access to the processing of personal information. To give effect to this, you must take reasonable measures to identify possible risks to personal information in your possession or under your control, Establish and maintain appropriate safeguards against the risks identified. Verify that the safeguards are effectively implemented. Ensure that these safeguards are constantly updated in response to new risks or deficiencies in previously implemented safeguards. You must have regard to generally accepted IT security practices and procedures which are applicable or required in terms of specific industry rules and regulations. If you are unlawfully sending information, or whether you're not sending information to a third party lawfully, the information must be processed with the knowledge and authorization of the responsible party, being you of course. Such information must be treated as confidential unless required by law or in the course of proper performance of their duties. A written contract must be entered into with a third party, ensuring that the third party has security measures in place that is similar to those that you have in place. The third party must notify if any unlawful access or acquisition of such information. Let's say, for example, you run an accounting practice that still relies on hard copies. You have an entire safe room or archive where all your documents are stored at the end of each working day. You have ensured that this room is fireproof. You have burglar bars in place, and the whole premise is also monitored by security cameras. The possible risks that might come around here is possibly the room is not fireproof, or the security bars can be broken down somewhere or another. The security cameras might be dysfunctional, or the doors are left open. You must ensure that you can tackle each and every one of these risks to ensure proper security is in place. Let's say, for example, you're using electronic storage, Dropbox, Microsoft, anything of the sort. If you're using any of those security providers, you're looking at where that information is stored. It is most likely stored overseas, and as such you'll have to ensure that you comply with the security safeguards rule in that instance. It would be best practice to have written proof in place to ensure that you know and have been convinced in terms of this person's or this entity's undertaking that this information is protected in terms of either POPI or the GDPR or whatever applicable law. And then based on that undertaking or statement, trust that entity with that information. So it's the practice of due diligence and verification. Ultimately, if a breach happens in the hands of this third party, whether or not it is Dropbox or a local business offering cloud storage solutions, it doesn't matter. Ultimately, if the breach occurs in their hands and you can say you were under the impression, based on their statements and the undertakings that they are in terms of that they are compliant with data protection, you will not be penalized in that instance, for you have acted reasonably in that instant. So it's all about trusting the other person who's also going to have access to this information and making sure that you have reasonable practical grounds for trusting that person or entity. Furthermore, when a breach occurs, this would be anything of the sort: theft of information, hacking into your security systems and stealing your file contents, anything of the sort. That would be regarded as a breach where that access or breach was unlawful and unauthorized. A certain procedure needs to be followed. You must notify the information regulator of this breach. The data subject concerned must also be notified, and this must be done as soon as possible unless the subject's identity cannot be established. The notification must be done as soon as possible, taking into account the needs of law enforcement or measures to determine the scope of the compromise and restore the integrity of the information system. The notification may be postponed if it is determined by a public body that such notification will impede criminal investigation. The notification must be done in at least one of the following ways: mail to the subject's last known physical or postal address, sent by email to the subject's last known email address, placed in a prominent position on the website of the responsible party, published in the news media, or as may be directed by the regulator. Furthermore, the contents of the notification of the compromise are as follows: a description of the possible consequences of the security compromise, a description of the measures that the responsible party intends to take or has taken to address the security compromise, a recommendation with regard to the measures to be taken by the data subject to mitigate the possible adverse effects of the security compromise, and if known to the responsible party, the identity of the unauthorized person who may have access to acquire the personal information. The regulator may direct the responsible party to publicize in any manner specified the fact of any compromise to the integrity or confidentiality of personal information, if the regulator has reasonable grounds to believe that such publicity would protect the data subject who may be affected by the compromise. I have seen, I myself as a data subject have been, victim of data breaches, not only my data alone, but myself and many others. The first thing that happened was I received an email that, it's a particular gym that I'm going to, that their information system has been hacked or unlawfully accessed. They are taking the necessary steps to ensure that is not happening again. They make use of electronic card systems, and for at least 2-3 months afterwards, you were not able to swipe a card and access in. You had to sign in with your membership details or membership number and then continue in. All online services for this entity was down until they could ensure that everything was back in order again. So it's very interesting to note, but also very reassuring for once, or when that paw hits the fan, that the right steps are being taken. Condition 8 relates to data subject's participation. The Act affords the subject various participatory rights, including the right to confirm whether or not the responsible party holds personal information about the subject, the right to request information that is in the possession of the responsible party. Notwithstanding the above, a responsible party may refuse to disclose any information to which the grounds for refusal of access to records set out in the applicable sections of Chapter 2 of Part 4 and Chapter 4 of Part 3 of the POPI Act, namely the following: protecting a third party's privacy, protecting commercial records of a third party in terms of agreement, protecting confidential information in terms of an agreement, protecting the safety of a person, protecting information in legal proceedings for national security purposes, and so on. The manners for requesting access to, or correction or destruction or objection to processing is prescribed by the Act. In receipt of the subject's request of whatever nature it may be, the responsible party must carry out the instruction, provide the subject with credible evidence in support of the information, or indicate that a correction of the information has been requested but has not been made, advise any interested parties relating to change the information if the information has changed to such an extent that an impact has been made. The subject to which the information relates must also be notified of the action taken as a result of the request. POPI prescribes forms of request, summarized as follows. Now, these would be in the prescribed forms as set out by POPI. Firstly, the requests are addressed to the information officer at the indicated address as per the manual. The form must require provision of particulars to enable the officer to identify the records requested, the requester, format of access, and state whether the records should be in a certain language, provide a postal fax or email address, and then it's sent to the relevant information officer for consideration. So, in a nutshell, POPI compliance alone can already be based on at least following these 8 conditions. That would be regarded as your bare minimum compliance. It's not very complex, despite the fact that it sounds Greek in at least 6 different languages. But is something that, even if it sounds elementary or not really relevant to your day-to-day business, if you're not compliant with POPI and something happens to a person's information, or a person comes from the outside and sends a complaint against you at the personal, at the information regulator, and you're not compliant in any way whatsoever, you may be subject to fines or possible imprisonment as a penalty for your non-compliance. As a result, I would consider at least looking at the previously mentioned 8 conditions of processing. But in a nutshell, ensuring POPI compliance, you should firstly make sure you understand the Act to a certain extent, and you have appointed an information officer. Conduct an analysis of the personal information you have already collected and retained in the process from the get-go, paying special attention to the purpose for collection of information, sources of and quality of information, what the information is used for, why the records are retained and for how long, the security measures to protect the information, the consents on record, what constitutes special personal information, how it is treated, conduct a risk assessment on the measures to protect personal information, revisit relevant policies to ensure compliance with POPI, ensure that contractual arrangements with third parties are in place with whom information is shared, provide training to your employees or colleagues to ensure compliance with POPI. So, as I have said, non-compliance can boil down to the imposition of sanctions or penalties that are regarded as criminal in nature. So the penalties may include fines maximum of 10 million rand or imprisonment of a maximum of 10 years and so forth. In my practice, I've assisted various entities already with setting up certain sets of documentation, and as such, although the Act does not prescribe X, Y and Z information, I can at least guarantee that this would also furthermore assist you with your paper trail of compliance. And again, this is just a suggestion, and you're more than welcome to contact me if you'd like any further assistance in this regard. Firstly, a POPI manual. It is good practice to have a POPI manual, as it contains the rules of POPI which are also applicable to POPI. Also sets out key information regarding information practice in the business, and it is compliant with the conditions of processing 1, 2, 3, 6, 7 and 8. So that's already a majority compliance there and then. A privacy policy in place, which I would regard as the foundation of your processing framework. This should be available upon request or publicly available. In any event, it sets out basically everything that is contained in section 18 of the Act as required, and is also going to provide you with various levels of compliance in terms of the conditions of processing. Furthermore, I would suggest using spreadsheets or any other tool to analyze what personal information you have in your possession, why it's used, how it's collected, how it's stored, and possible risks. Using this, you can possibly identify various risks and then come up with your own solution as to how to mitigate the possible happening of such a risk. There are various tools available by various practitioners, and like I said, you're more than welcome to contact me for any further assistance in this regard. Furthermore, section 18, as I previously mentioned, this can include collection notices, consents and addenda to current contracts and agreements. Furthermore, also documents describing protocols to be followed in cases of breaches and logs of access requests. And again, this would also assist in further security of information in the practice. Alright, thank you for listening. If you have any questions, you're more than welcome to email me at this address, send a WhatsApp to this number, or possibly try and call me. Always free to discuss this over a cup of coffee or anything of the sort. And thank you for listening, and thank you for attending. Thanks.